Hi, good afternoon to all of you. So, I would welcome you all for this current affairs, and today I am going to take up some of the current topics from science and tech, thereafter from polity, constitution, thereafter from social issues on which the possibility of question in the prelims 2020 is high. So, I will take up, right, I will randomly take up some topics from first science and tech, thereafter from polity and constitution, and thereafter from social issues, and we will try to discuss those topics the way it was covered by media and some additional information which is there. So, the first topic which I am going to take up for discussion is the successful user test trial of Helena. Okay. So, I hope you all are aware with the fact that in the month of July 2020, a great news for India when we tested fire Helena missiles, successfully, and it was a user trial. Okay. Helena is helicopter launched variant of Nag, right? Basically, Helena is helicopter launched variant of Nag, and I hope you are aware with the fact that Nag is anti-tank missile. It is one among the 5 strategic missiles which India has developed under integrated guided missile development program. So, it is one of the, right, it is one among the strategic missile under integrated missile development program of India, one of the strategic missile. I hope you are aware that in this integrated missile development program, we have been successful in developing Agni, Prithvi, Trishul, Akash and Nag. Okay, we launched this integrated guided missile development program. So, Agni and Prithvi, they are surface to surface missile, whereas Trishul and Akash surface to air missile, and Nag is, right, Nag is anti-tank missile. Okay. So, one of the strategic missile which we have been successful in developing under integrated guided missile development program is Nag. And before I tell you, because now Helena has been named after this successful trial in July 2020, we have successfully tested fire, Now it has been named as Dhruvastra. This is very important development. This you must remember. Now it has got a new name, Dhruvastra. Okay. Why it has been named as Dhruvastra? This is very important, right? This is very important that Helena, when user trial was successful in July 2020, has now been named as Dhruvastra. I would just like you all to remember, for the first time way back in 2015, in July 2015, we conducted 3 test trials for the first time, and out of 3, 2 were successful and 1 failed in 2015. Then we continued with the research part, designing and development part, and again we conducted the test fire in August 2019, okay, August 2019, and thereafter thereafter we also conducted a test fire in Feb 2019, this August 2018, sorry. So, first time 3 test trials were conducted in the July 2015, thereafter in August 2018, then in Feb 2019, and thereafter it was decided that we will go for, we will go for user trial, where the end user will use it, okay, end user will use it, and this is what we have done now in July 2020. And when user trial was successful, now we can say that it is all set to get inducted in Army and Indian Air Force for use, and definitely it will place India very, very strongly the way the stress is building along LAC, and there is no need for me to tell you the kind of situation which has emerged and evolved at LAC, particularly Pangong Lake, Galwan Valley, okay, Chusul, Blacktop Hills. These are the areas where quantum of stress between the two armies is very, very high. Okay. So, what I am just trying to say, in this kind of situation, successful test trial, user test trial, and thereafter Helena being named as Dhruvastra, a very important development which you should remember. And as far as Nag is concerned, Nag is third generation missile, okay. It is, right, it is based on fire and forget technology, okay. Effective range of Nag otherwise is 4 km, but when it comes to Helena, which now is known as Dhruvastra, it is effective range is 7 to 8 kilometers. And what is the meaning of third generation missile and fire and forget technology? One limitation which is there in the first two generation missiles, that missiles when is fired from the launcher has to remain aligned with the target till missile hits the target. If there will be any movement in the launcher, then missile will not hit the target. This is the biggest limitation in the first two generation missiles which are there with different countries of the world. Have you understood this? Just try to understand. Let us suppose this is a missile, this is a launcher. So, what is the limitation? Once missile is fired from this launcher will have to remain aligned with the target till missile hits the target. But what is fire and forget technology? Right? Everything, because in the first two generation missiles, after missile being launched, it is guided by launcher. But third generation missiles are fire and forget. So, user just has to fire and then can forget all about it. Yet the missile will hit the target with accuracy. Why? Because missile is capable of guiding itself. And before the launch, infrared image of the target is, feeded in the missile. The grid of target is feeded in the missile. The coordinate of the target is feeded in the missile. And then missile is capable of guiding itself. So, there is no requirement for launcher to remain aligned with the target. And launcher and the man who has launched it can move immediately after the launch. This is the biggest benefit of third generation missiles. Because the vehicle from which missile is launched and the people who are involved in the launch, they are vulnerable to counter attack. They must move immediately away from the place of launch. Okay. So, Nag is a third generation missile. It is based on fire and forget technology, and now helicopter launched variant of Nag, meaning it will be fitted in helicopter, and while the helicopter is flying in the mid-air, the missile can be, fired. Nag is basically an anti-tank missile, meaning what? This missile is used to blow up tanks in the battlefield. Okay. So now from the helicopter, the missile will be fired towards tanks, enemy tanks in the battlefield, and the missile will blow up the tank. Okay. So 7 to 8 kilometer is the effective range of this Dhruvastra. And let me just tell you that this missile, right, this missile is going to be fitted on HAL, that is Hindustan Aeronautics Limited Advanced Light Helicopter, ALH Advanced Light Helicopter. Hindustan Aeronautical Limited has designed and developed this, and we have named this helicopter as Rudra. Rudra. Okay, this is the LCH manufactured by Hindustan Aeronautics Limited, Rudra. So now on Rudra we will have Dhruvastra. Okay, and this Dhruvastra is helicopter launched variant of Nag missile, and it's all set. Okay, it's all this was very much needed. The kind of stress which is building along the LAC, it is very much needed. So you should remember, Helena successfully tested fire, and this was successfully tested fire at interim test ITR Odisha. Okay, it was tested fire at ITR Odisha. Okay. Earlier we were testing fire at Pokhran firing range, but this time we have tested fire, right? This time we have tested fire is at integrated test range which we have at in Odisha, in Balashore district of Odisha. So Helena has been named as Dhruvastra, number 1. Number 2, effective range of Helena is 7 to 8 kilometer. Number 3, it is a 3rd generation missile based on fire and forget technology. Number 5, right? Number 5, it is the helicopter launched variant of Nag missile, and Nag is something which we have developed under Integrated Guided Missile Development Program. So this is one very important development which you should keep in mind. Another very important development, right, relates with a new policy which we have drafted, and which is going to be implemented. And why new policy we have drafted? Because we started using this in the to combat this COVID-19 and thereafter the lockdown. So I am just going to take up for discussion the unmanned aircraft system rules 2020, right? Rules 2020 I am going to take up for discussion. And media has popularized these rules as drone regulations variant 2.0, because drone regulation variant 1.0 was already in place since 2018, but all of a sudden to fight the pandemic and COVID-19 in India, we saw that government permitted the use of drone for surveillance purpose, for disinfection, whereas disinfectant will be sprayed through drones, and even for videography for effective lockdown and containment zones, monitoring, surveillance. So a lot of drones are being used, and it was definitely giving birth to a serious kind of threat, because you know well that drones, if is used by criminal elements, anti-social elements, okay, then by terrorist organizations, so it can be disastrous. So in the backdrop of this, now the government has come up with a new regulation, and those regulation have been tagged as drones regulation 2.0 version, which is an improvement over 1.0 version, which was otherwise in the government policy document, it finds a mention in the name of Unmanned Aircraft System Rules 2020. Unmanned Aircraft System Rules 2020. Now, I would just like you all to remember that all of a sudden what country has seen, right? Significant increase. So, we were left with no option, very significant increase in the use of drones, okay, for which all purpose? Surveillance, disinfection, and videography, right? Videography in the, while we were combating coronavirus. So, we thought that now the time has come when we should amend the rules of 2018 and we should put in place, new rule. So, as far as drones are concerned, first thing I would just like you all to remember that drones means what? Unmanned aerial vehicle, and they are remotely piloted aircraft, right? Drones remotely, you can say remotely piloted aircraft, or you can say unmanned aerial vehicle. Drones are unmanned aerial vehicle. When it comes to unmanned aerial vehicle or you can say remotely piloted aircraft, right now we are classifying them in 5 categories. 5 categories based on weight, and weight governs the size. So, nano drones, then micro drones or micro UAV, then small, then medium, and then large, Okay. So, nano, micro, small, medium, large. Nano is, less than 250 gram, less than equal to 250 grams. Okay, if the weight of the drone is 250 grams or below, then it is termed as nano. If it is, if it is more than 250, grams and up to 2 kg, then it is within micro category. Okay, micro category. Then more than 2 kg, but up to 25 kg, then it is a small. Okay, then it is a small. More than 25 kg, but up to 150 kg, then it is medium. And if it is more than 150 kg, then it is large, right? Then it is large. So, what exactly you have to remember that now what the government, right, now what the government has said, right, what the government has said that only, right, only under the new policy what the government has said, only nano class drones, only nano class under the version 2, nano class drones will be allowed to operate, in general, and only a qualified pilot will be permitted to operate heavier drones. So, only which are heavier than nano class, only a qualified pilot can operate. So, heavier drones, only qualified pilot, they will be permitted to operate. This is one big change, because see, means a lot of issues are there. Okay, it is a double-edged sword. We can use it, but if somebody is hell-bent on abusing, you can't even imagine security, safety, privacy, everything is threatened. Okay, drones can be used and somebody privacy may get intruded. If heavier drones are being used by those pilots who are not qualified, who cannot control the remote properly, if there is accidental fall, it can cause severe damage to life and property. And security issues, there is no need for me to tell you. Okay. So, what I am just a small quantity of explosives, if can be exploded through drones which are remotely controlled, then you can imagine what quantum of damage it can cause. So, first thing which has been there in this new policy, that nano class drones will be allowed to operate in general and only qualified pilot will be permitted to operate heavier drones, right, heavier drones. Not only this, right, not only this, the biggest is the most important change which we have brought, that only individual or entity who are approved by, you might have heard about DGCA, Directorate General of Civil Aviation, DGCA, Directorate General of Civil Aviation, only those who are permitted by DGCA, who are approved by DGCA, to them only any drone manufacturer can sell device to them. Okay. So, it is not that you can go and purchase. If you want to get a drone, you will have to first seek the approval from the DGCA that you are interested in purchasing the drone, and only when you are someone who is approved by DGCA, whether a firm, whether an entity or individual, then only the manufacturers can sell this to you, or you can even import only when you are permitted or by DGCA direct. So, we have brought it under complete regulation by this new provision that any drone can be sold only to an individual or entity who are approved by DGCA, and there is a digital platform through which you will have to apply if you are interested. Tomorrow if authorities will find that you are using drone, right, maybe for playing purpose, okay, maybe from playing purpose, then action can be taken. It will be the violation of this policy. Okay. So, that is something. So, this is very important change which has been brought. Only individual and entity approved by DGCA, to them only there can be sale of devices. Okay. This is a very important change which has been brought. And third is, DGCA can inspect any unmanned aircraft system manufacturing unit, or any maintenance facility center, right, anytime, and based on inspection report, there can be cancellation of license which they have for manufacturing of such devices or such you can say system. Okay. So, there can be inspection by DGCA, the Directorate General of Civil Aviation, any manufacturing unit or their maintenance unit or any such premises can be inspected by DGCA at any point of time, and their manufacturing license can be cancelled if they are finding the non-compliance of the directives which are there for them. Okay. So, these are some of the very important changes. These are some of the very important changes. In addition to this, one change relates with third party insurance, okay, and only when some entity is using or individual is using the drone, there must be a third party insurance for the use of that drone. Only when there is a third party insurance, then only it can be used. Okay. Then fourth, which is the most important, I would say, that payload regulation. Payload regulation. Meaning, what is payload? What can be carried by the drone? Okay. What can be put on the drone? Camera udhar put karega, disinfectant put karega, chemical put karega, okay, pesticide you can put, all those things. So, there is payload you can say regulation, and it has been decided that no unmanned aerial system can use any payload except permitted by DGCA. So, DGCA has came up with a list that these are the things which can only be installed in the form of payload over the drone, otherwise no other form of payload will be permitted. So, a lot of payload, you can say regulation is there, and age criteria you should remember. Drone can only be used by those who are 18 years and above. It cannot be used by children below 18 years, because nowadays what we were finding that when such things are coming to the notice of the authorities and when we are going to take action, the people are claiming that it is being used by the children for purpose of playing. Okay. So, no, now under new policy, no drone can be used by those, okay, for play purpose, and it can only be used by children who are 18 years and above. And I would also like you all to know in this regard that for the first time, the Independence Day ceremony which we conducted at airport, we deployed anti-drone system. So, 15th August, this also is another important news, 15th August 2020, 15th August 2020 at Red Fort, where we conduct the national ceremony, Red Fort. DRDO developed an anti-drone system which was deployed, and this is again considered a major milestone. Anti-drone system was deployed. We used this anti-drone system for the security of the Prime Minister, and under this, this anti-drone system which we deployed for the security of the Prime Minister during Independence Day celebrations at Red Fort, that anti-drone system is capable of detecting micro drones, okay, micro drones, okay. So, and all drones which is up to 3 kg, you can say, Basically, any drone which is between 250 gram to 2 kg falls within the category of micro drones, but the anti-drone system which we installed at Prime, capable of detecting any kind of micro drones up to, you can say, 3 kg, meaning even very small drones also can be detected by this anti-drone system which we deployed. And not only it can detect micro drones, but it can also, right, it can also neutralize those drones by using laser. Okay. So, this anti-drone system uses laser and can bring down any target up to 1 to 2.5 kilometers, 1 to 2.5 kilometers. So, targets which are in the range of 1 to 2.5 kilometers can be brought down with the use of laser by this anti-drone system, which has been designed and developed well by DRDO, and we use that anti-drone system this time for the first time for providing a security to our Prime Minister when he participated in this Independence Day celebration at the Red Fort. And let me tell you, we are using this anti-drone system, we are going to use this critical, infrastructure, defense installations. We don't want, our defense cantonments and installation to be photographed with the use of nano or small drones. Okay, so this is why anti-drone system is very, very important. Any particular premises which is vital, which is critical, if we have to protect, we need anti-drone system, and DRDO has now, developed. So, for two things drone was in news. Number one, anti-drone system designed and developed by DRDO, used very effectively for the first time to provide a foolproof security cover to our Prime Minister on Independence Day. And now drone regulation version 2.0 in place, okay, in the backdrop of COVID-19, lockdown, disinfection, spray, okay, all those, and all these things are important. So, these are the three very important development. Next topic which we are going to take up for discussion, that relates with polity and constitution, and very, very important, right, very, very important. And I am going to talk about one historic judgment of Honorable Supreme Court of India. You all must have read about the judgment. Okay, I hope you all might have read about this judgment. Okay, so let me just tell you this judgment of Honorable Supreme Court of India. This judgment says that historic judgment given by Supreme Court in August 2020, in which Supreme Court has said women will have co-parcenary right, right, co-parcenary right, irrespective of father was alive or not. A historic judgment, a landmark judgment by Honorable Supreme Court of India. Social scientists, human right activists, women right activists, constitutional experts, legal luminaries, they all have said that this judgment of Supreme Court will not only deal with the ambiguity, has removed the ambiguity related with the law, but will go long way in achieving the goal of gender justice in India. Okay, so you need to understand everything about this, judgment. And while judgment was being pronounced, the judge of Supreme Court, right, the judge of Supreme Court on a lighter note said, once a daughter, always a daughter. And not only Supreme Court said once a daughter, always a daughter, but Supreme Court on a lighter note even said that son is a son till he gets wife, but daughter is a daughter throughout life. Okay, that was said by the Supreme Court on lighter note. This judgment actually relates with Hindu Succession Act. Okay, so I would just like you all to remember, I just want you to remember everything about this judgment, very historic judgment. Okay, so this judgment basically is related with section 6 of Hindu Succession Act, Hindu Succession Act of 1956, which was actually amended in 2005, and through this amendment the earlier section 6 was scrapped and new section 6 was inserted. Okay, so this is something which you should understand, right? You should understand that this historic judgment of Honorable Supreme Court of India is related with Hindu Succession Act. Hindu Succession Act is of which year? It is of 1956. Okay, it is of 1956, and this Hindu Succession Act was amended in which year? 2005. And through this amendment, what was the most important change which was brought? Whatever was the provision in section 6 of 1956 Act was scrapped, was removed, and a new provision was added in section 6 of Hindu Succession Act. And it basically relates with co-partnership rights of women. And many of you who are not from the law background or who has not studied political science or sociology or public administration, they may not be aware with this term co-partner. So I would just like you all to remember this, that legally when we are using this word co-partner, who is a co-partner? Someone who has right to demand partition in undivided ancestral property. So someone who can demand partition in the property, they are known as co-partner in law. Okay, so co-partnership rights we have given to daughters under Hindu Succession Act. It was there. Please don't confuse. Co-partnership right was earlier there. Since 2005 it is there. But there was ambiguity. Okay, there was ambiguity. That ambiguity got removed through this historic judgment of Honorable Supreme Court of India. Right? Why this ambiguity was there, I will tell you. But before this, they may not ask about the judgment, but you need to see. All of you, are you aware about personal law? Okay, so in law, what is personal law? Law which relates with marriage, which relates with divorce, which relates with inheritance, which relates with succession, which relates with adoption, They fall within the category of what? Personal law. Okay. Now, in India, you know well, for different religion, different personal law. Okay. But the personal law which is applicable to Hindus are also applicable to those who believe in Jainism, those who believe in Sikhism, those who believe in Buddhism, and even those who are from Brahma Samaj or who are from Arya Samaj. But for Muslims, there is a different personal law. For Christians, those who believe in Christianity, there is a different personal law. You must have studied about the directive principles of a state policy. You must have studied about Article 44 Uniform Civil Code. Till now, it's not there. Only thing I would just like you all to remember that as far as, school of Hindu personal law is concerned, we have two. If we see the schools of Hindu laws, then we have two schools. One school is Mitakshara Law School. Mitakshara Law School. And second is Dayabhag Law School. And there is, some difference as far as Succession Act, succession laws are concerned. As far as this Mitakshara Law School is concerned, okay, I don't want to burden you with facts, but I would just like, this Mitakshara Law School is observed in all parts of India, exception is West Bengal and Assam. And this Dayabhag is observed in Bengal and it is observed in Assam. Okay, it is, observed in Bengal and it is observed in Assam, Dayabhag. Whereas in rest part of India, Mitakshara school is, right, Mitakshara school of law is applicable. Now, under Mitakshara Law School, right, under Mitakshara Law School, son, earlier this is what used to be the provision, son by birth acquires interest and claim in ancestral property, but, right, but in this Dayabhag, son don't enjoy coparcenary rights when father is alive. Only when father is dead, father is alive. Only when father is dead, then they have coparcenary rights and they have claim in the ancestral property. This is one difference which is there. Okay. And one thing you will find in Mitakshara Law School, a copartner shares is not defined and cannot be disposed, meaning right will be there. Okay. So, let us suppose that father has, X quantity of wealth, son will have right in that wealth, but which part of the wealth belong to which son, that is not defined in Mitakshara. and this is the reason why it cannot be disposed. Okay, it cannot be disposed. And since in Daya Bhag Law School, what is the provision? Co-partnership rights is only after father's death. Therefore, what used to be there? During the lifetime of father, he can dispose of. Okay, he can dispose of the property. So, I am not interested in teaching you law in current affairs. I just want you all to have this awareness, right? To have this awareness that two schools of law. Now, all confusion started, right? All confusion started with very different kind of judgments which were given by Supreme Court and High Courts in India. But even in Supreme Court, 2015, see, Hindu Succession Act was amended in 2005. Co-partnership rights were given to women. But in 2015, one judgment was given by Supreme Court in Prakash versus Fulvati case, and in this judgment, right, the Honorable Supreme Court said that co-partnership benefits can be granted only to living daughters, of living co-partners and this should be on September 2005. This was the judgment. So, what was said by Supreme Court in Prakash versus Fulvati case? In Prakash versus Fulvati case, Supreme Court said that co-partnership rights with daughters are only when they are claiming the right, the daughter is alive and the father is alive. Okay, and this should be the scenario on September 2005 when this law came into enforcement. This amendment came into. They cannot have rights before September 2005. This was the judgment given by. So, condition was set that only rights will be, right, only rights will be for those whose father is alive and whose daughter is also alive, and this will only be applicable for, September 2005 if on that day. Before that, it's not applicable. This was the judgment which was given by Supreme Court, two-judge bench Supreme Court. But again, in 2018, in Feb 2018, Supreme Court in Dhanamma, and she was more popular in the name of Suman Surpur versus Amar. Now, in this case, Honorable Supreme Court of India said that co-partnership rights will be, can be availed by, daughter whose father died in 2001 itself. So, a conflicting judgment, a different judgment was given in Feb 2018, right, in Feb 2018. What was the, judgment in this case? Dhanamma, that the share of father who died in 2001 will pass to his co-partner daughter. Okay. Again, right? Again, in April 2018 and all these judgments by two judge, April 2018 in Mangamal versus TB Raju, the Supreme Court reinstated its earlier position taken in 2015. So, this was the reason why there was ambiguity. So, it was decided in 2018 that this should be referred to a higher bench. So, the matter was referred to a higher bench, 2000, right, 2018 only it was decided that it will be referred to a higher bench. So, 3-judge bench now has, right, given the judgment, and this landmark judgment, if you see the key highlights of this judgment, basically it says that right to property under Hindu Succession Act, property is same between sons and daughters. Okay, right to property is same between sons and daughter. This is what is the first thing under Hindu Succession Act said by the Supreme Court now. And not only there is right to property is same between sons and daughter, but liability too is to be shared. Liability too is to be shared. Is to be shared among them. Okay. So, if means who will look after the father, who will look after the mother, who will look after the grandparents, right? The grandchildren, both grandson, granddaughter, whatever liability, if they have taken any debt, who will repay? Son and daughter both will have to repay as well. So, what has been said by the Supreme Court, that the liability is also to be shared. It is not that daughters after getting married one fine day can come back and can ask for, right, the share in the property, but they will not have any willingness to share the liability. So, very very specifically the Honorable Supreme Court in this judgment has said that liability is also to be shared among them. And third, clarity that no restriction of timeline, no restriction of timeline. Okay, so what has been said? What has been said by the Supreme Court? You cannot say that this rights, co-partnership rights to daughter will be only to those, right, only to those who are born after 2005, or only to those whose father is alive, or only to those who, if daughters are alive, so on and so. So, no restriction of timeline. Very, very clear position has been taken by the Honorable Supreme Court of India, and very specifically they have said that not necessary that father is alive to claim this right. There is no need that the father is alive, then only they can claim, or even daughter is alive. Have you understood the meaning of this? Daughter is alive. You cannot say that daughter has died, so their children will not have claim over the property which they were entitled for. Okay. So, even if daughter died and their children can put a claim, that will be very much there. So, not necessary that father is alive or daughter is alive is another, right, another. And what has been said, that all these, the rights as well as liabilities both will be by birth irrespective of gender, by birth. So, co-partnership rights will be created, by birth, by virtue of birth, and irrespective of gender it will be. Okay. Now, two things very categorically the Supreme Court has cleared, okay. Number one, right, number one, property which got distributed, property distributed before 20th December 2004 cannot be disputed. With this judgment, nobody can dispute the property which got distributed before 20th December 2004. Okay, if distribution has happened, now nobody can come forward and can dispute again what was already settled. Okay, and second is all pending, because large number of such cases are pending. So, pending cases to be decided within 6 months. So, Supreme Court has asked all high courts in India that all pending cases must be decided within 6 months. Okay. And what all can be the, what are the different significance of this judgment that you will have to prepare, what all challenges are associated with this judgment, you will have to prepare from the main point of view. That time I will discuss, but just significance of this judgment. What is the legal significance of this judgment? This this judgment is going to bring to an end the legal ambiguity about Section 6, and this legal ambiguity was primarily arising because of conflicting position taken by Supreme Court itself. Okay. So, this is one significance of this judgment. What is the constitutional significance of this judgment? This judgment will strengthen the constitutional spirit and the constitutional philosophy of equality. Okay. What is the social significance? This judgment will help us achieve the goal of gender justice in India, women empowerment, right? Because you know well, we will talk that economic, social and political empowerment goes hand in hand. But if you ask me, what are the challenges which are going to be there? The biggest challenge is arising because of the patriarchy, in India, or patriarchal nature of Indian society. Neither many girls will not come forward after marriage to claim their rights in the ancestral property, nor brothers and fathers will be, eager and interested to share the property with daughters for sure. So, patriarchy in India is going to be, and lack of awareness amongst women. So, too many things we have to discuss, but from prelims point of view, this is what you should remember. Another important thing, right, another important thing what I would say, and again only from the prelims point of view, one more historic judgment of Supreme Court, and this is a bench, constitutional bench judgment. You should only remember the judgment. We will do the analytical discussion. I am expecting a question in the main exam on both these judgments, and equally important from the prelims point of view. Now, what Supreme Court has taken a position. Supreme Court through a judgment has now taken a position that subclassification of reserved class or classes, you say, sub-classification of reserved classes, right, is constitutional. Right. Sub-classification of reserved classes is constitutional. This stand has been taken by, taken by Honorable Supreme Court of India, right? Honorable Supreme Court of India in one of the case which is related with Punjab, right? Related with Punjab, and Supreme Court has said that there can be sub-classification within scheduled caste, within scheduled tribes, within, right? Within this socially educationally backward classes. Okay, what is the stand? That sub-classification of reserved class, and this sub-classification can be within scheduled castes, it can be even within scheduled tribes, and it can be within those who are socially and educationally backward, SEBCs. There can be sub-classification within the class. And what, right, what Supreme Court is saying? What Supreme Court is saying? That weakest, now what Supreme Court is saying? Weakest out of weak, weakest out of weak are entitled under Constitution of India for preferential treatment, right? Preferential treatment. Okay. And this stand which has now been taken by Honorable Supreme Court of India, right? This stand which has been taken by Honorable Supreme Court of India is, right, is in conflict with its own judgment which it gave in E.V. Chinnaiya case. E.V. Chinnaiya versus State of Andhra Pradesh case in 2005. So, in this, a 5-judge constitutional bench, 5-judge constitutional bench, okay, said that the state government has no power to subcategorize scheduled castes for the purpose of reservation. A very strong judgment was given by Honorable Supreme Court in E.V. Chinnaiya versus State of Andhra Pradesh case in the year, right, in the year 2005, and in that case the Honorable Supreme Court of India, constitutional bench, 5-judge constitutional bench said that no state government can create subclass or subcategories within scheduled caste for the purpose of reservation. But now this case, you should remember this 2020 judgment that there can be subclass, this judgment has come in which case? This is a state of Punjab versus Davinder Singh, okay. This is the observation of Supreme Court. I will tell you the technical point. You need to understand this technical point. Okay. So, this is the judgment of, right, this observation of Supreme Court is in which case, right? This observation of Supreme Court is in this case of State of Punjab versus Davinder Singh in 2020, and this, you know, basically is, this case is about section 4 clause 5 of Punjab scheduled caste and backward classes reservation in service, reservation in service in Services Act 2006. Okay. And what actually was done by, you know, this section actually allows 50% reserved seats of scheduled castes to be allotted, right, to be allotted to two communities. One is Valmikis, okay, and second is Mazhabi Sikhs. Okay, so Punjab has amended the law, and through the amendment in the law, what has been done? What has been done? That two caste within scheduled caste, for them 50% of the seats in services for has been reserved. This constitutional validity of this was challenged in Supreme Court in the name of case State of Punjab versus Davinder Singh. But only thing is that for this a constitutional bench of 5 judges was constitutional bench of 5 judges was constituted. Now that constitutional bench of 5 judges, they observed that there can be sub-classification of reserved class, and that is based on that weakest out of weak should be given preferential treatment, and that kind of steps by step government is valid. But this observation is in conflict with what Supreme Court stand was taken in 2005, and therefore this bench now has referred the matter to a higher judge constitutional bench. So already, 7 judge constitutional bench has been constituted to look into the matter. Judges requested the Chief Justice of India to constitute, because a 5 judge constitutional bench cannot overrule the judgment given earlier by 5 judge constitutional bench, but they have given their observations, and they have said that what stand was taken by Supreme Court in 2005 is wrong, because the concept of reservation is based on the concept of social justice, and if we want social justice, right, then the weakest out of weak are entitled for preferential treatment. If this is a discrimination within the class, even then, right, and the Supreme Court said that if you will not allow sub-categorization, then benefits will be taken by few, and within that category large number of people will remain outside the ambit of benefits, okay, and that will induce divides within the category, and that may give birth to caste struggle within reserved class. Okay, caste struggle within reserved class. This was the observation of Honorable Supreme Court. Okay, so only thing what I would like you all to remember, what is the whole story you need to remember from prelims point of view, that in the state of Punjab, right, Punjab Scheduled Caste Backward Class Reservation in Services Act 2006 got amended, through which a new clause has been added in section, right, 4, which talks about allocating 50% of the seats reserved for scheduled caste for 2 communities, that is Valmikis and Mazhabis Sikh. And this has now been challenged in the Supreme Court through State of Punjab versus Davinder Singh. The position of the constitutional bench is in conflict with the position which was taken by Supreme Court earlier in 2005. So now the matter has been referred to 7 judge constitutional bench. But this observation has ignited an intense debate in the country among social scientists and political scientists, right. So that is something which you should remember, right, that is something which you should remember. And in relation to this, I would just like you all to remember one thing, that Union Cabinet has approved 6-month 6-month extension, 6-month extension to the commission which is examining subcategorization of OBC. So, already we have created a commission which is examining subcategorization of OBC, other backward caste. And if you read newspaper, you must be knowing that who is heading this commission, right? Who is heading this commission? This commission is being headed by Justice Retired G. Rohini. And this commission was constituted under Article 340 of Indian Constitution. Okay, and this was constituted in the year 2017. Okay, in the year 2017, this commission was supposed to submit its report, but now there has been extension in the term of the commission. Okay, there has been extension in the term of the commission, and it has been extended for 6 months. So, already government way back 3 years before constituted a commission to study that what can be the criteria, how many categories, subcategories can be created within OBC, okay, within OBC. And already in some states, I don't know how many of you are aware, if you go to the state of Bihar, within Dalit, there is a concept of Mahadalit, okay. So, subcategorization is there, but now once and for all that whole issue will get settled when the judgment will come from the newly constituted 7-judge constitutional bench. So, these two very, very important you can say judgments of Honorable Supreme Court of India, which relates with polity and constitution. Now, another thing which I would like to take up for discussion, and this has been in year long in discussion. Okay. So, whether it is in Uttar Pradesh, whether it is in Tamil Nadu, whether it is in Maharashtra, right? Maharashtra, one thing which has been in news throughout the year relates with anti-torture law. Anti-torture law. Okay, anti-torture law, and people are saying that after seeing the functioning of police in some parts of India, again there is a urgent and immediate need that there should be a separate anti-torture law in India. Okay, the time has come when we should create an anti-torture law, because you know, this whole issue came in the forefront after what happened in Tamil Nadu and what happened, right, what happened in this Uttar Pradesh. Okay, you know very well that one of the accused was arrested, and while he was being brought in very high, you know, in very high police security, there was road accident in which, you know, after which he attempted escaping the arrest, and then firing was done by the police and he was killed in an encounter. And many other who were involved in that case in Kanpur, okay, so they were killed in encounter rather than being arrested, okay, rather than being arrested. And that triggered a debate in India related with right, related with anti-torture law. So, UPSC will never ask you question on cases, but issues, right, but issues. And even more disturbing thing we heard about this from the state of, right, from the state of this Tamil Nadu, which relates with custodial death, and whole of the state was agitated. So, this is the reason why we just need to talk something about anti-torture, right, law in India. And in this, I would just like you all to remember few things, that in India there is no separate law against torture, no separate law against torture, okay, against torture, or and when I am talking about torture, I am also talking about custodial torture, okay. Torture is not even defined in IPC, but what is defined within IPC? Hurt, right? Hurt is defined, grievous hurt is defined, under IPC, Indian Penal Code, but there is no definition, right? There is no definition. But Supreme Court has come up with historic judgment way back and has issued guideline, and Supreme Court has said that if any policeman is found guilty of custodial death, then he will be only punished with capital punishment, death penalty. Okay. So, already the Supreme Court has taken this stand. You should remember that Supreme Court has issued a detailed guideline in D.K. Basu versus State of West Bengal, okay, and it has issued a guidelines. It has issued a guidelines which police has to follow in all cases of arrest and detention, arrest and detention, okay. And if we go by the guidelines which has been issued by Supreme Court, many a times, no, for example, right, right now, even if you see Sushant Singh Rajput suicide or murder, whatever it is going to be, right, because the matter is now being investigated by CBI, and some drug angle also got attached with the case. So, National Narcotics Bureau is also investigating the case. Some money laundering issue angle is also there. So, ED is also investigating the case, and the kind of media trial which is going on with few news channels, morning since evening, the way they are, no, I mean, what we are saying, that media must use their freedom, but with a word of caution, number one. And number two, they should not report something which can impact the ongoing investigation. Okay, many times they will, this is the sad thing which we are finding. Sensational journalism. You cannot just go on and on and on, and your reporting is creating so much problem for the agencies. Okay, so we will have a discussion on that from men's point of view, media trial and all those things. But what I am just interested, many times, many people in India, they have started asking, what nonsense, right? Why CBI is not taking, the suspects in under arrest? They can take only when they have some evidence, okay? And their evidence, when they present before the court, should withstand the scrutiny of the court. It's very important because it is, related with the reputation of the agency. They cannot work based on the emotions which are being aroused in the country by media when media is not well informed. And even if media is well informed, they are not, informing the people properly. I told you, the biggest problem, if you ask me, media is there to keep people informed, but rather than, informing the people, they are trying to build some perception. They are setting a narrative, and they want, everybody to think in the same line. And this is the biggest challenge which Indian democracy is facing today, that media is setting the narrative and there should not be any other discussion than the narrative which is being set by few media houses, which are under the control behind the curtain of powerful people. That is something which is there. Anyway, so what I am just trying to say, in D.K. Basu versus State of West Bengal, guidelines was issued by Honorable Supreme Court of India, which is to be followed in case of any arrest and detention. Otherwise, in India, we don't have any separate law to deal with custodial torture and even to deal with custodial death. But one thing what I would just like you all to remember in this regard, and this is what is in news, UN, right, UN CAT, United Nation, okay, United Nation Convention against torture, United Nation Convention against torture, and other cruel, inhuman or degrading treatment or punishment, right. So, this United Nations Convention against torture and other cruel, inhuman or degrading treatment or punishment, which is popularly known as UN-CAT, okay, UN-CAT. This convention is of 1984, and this convention came into enforcement on 26th June 1987. Convention is of 1984, but convention came into enforcement in 1987. India is, right, India is a party to this convention, participated in this, discussion. India is a signatory to this convention, but India has not ratified, right? India has not ratified this convention, and there is a demand which is coming forward after seeing the police functioning in different part of the country, that there must be, ratification of United Nations Convention against torture and other cruel, inhuman or degrading treatment or punishment. Okay. So, I would like you all to remember from prelims point of view that India is, signatory of UN-CAT, but India has not ratified. So, we have signed, right, we have signed, India has signed the convention, but India has not ratified, it has not ratified the convention. There is a demand which is coming. There is a demand which is coming that in IPC there must be proper definition of custodial torture, right. In IPC there is a demand that we should have a committee against torture in India at different levels, okay, at different levels, and there is a demand that the time has come when we should take big step forwards towards police reforms in India, and I am for, such reforms. It's the need of hour. We need to give police in this country functional autonomy. The biggest problem related to policing in India, related to law and order maintenance in India, related to fair investigation in India, that investigating agencies, police is not having the functional autonomy. And even Sushant Singh Rajput case is a burning example of the same, that Maharashtra police, when it started the investigation, now we have valid reason to say that their investigation was completely in the wrong direction. Okay. But when CBI is now investigating, that too under the order of Honorable Supreme Court of India, then investigation is progressing completely in a different direction. We don't know what will be the final outcome. It will be premature to comment. But we have seen even the Bihar police. Okay, now Bihar police has the right to investigate, to lodge FIR was what was concluded by Honorable Supreme Court of India, but the manner in which DGP of Bihar every evening will come in media and will speak, the manner in which the Commissioner of Mumbai Police will come and speak, and now we are seeing the lawyers of, father of Sushant Singh Rajput and the lawyer of Riya Chakravarti, every evening we find them in the news channel speaking something, right? And this is a, indicative of much larger problem. Definitely there should be justice for Sushant Singh Rajput. Under suspicious condition, he has met with death, whether it is, suicide or murder, it is to be investigated and established by the investigating agency, but for common man, we can very well sense that something is wrong. It's not the way it was presented in the beginning, based on preliminary inquiry which was done by Mumbai police. Now, question is not that. Question is that there is definitely somebody who is influencing the investigation from behind the curtain. And why is it so? Because police in this country is not having functional autonomy. Okay. So, what I am just trying to say, there is a growing demand. So, I would just like you all to remember this convention, right? Remember this convention. I would also like you all to remember that there is another, right? There is another thing which is related with this, which was in news, that is ICCPR. ICCPR, that is International Covenant on Civil and Political Rights. Civil and Political Rights. Okay. International. Now, as far as this ICCPR is concerned, International Covenant on Civil and Political Rights, this is a UN, right? UN General Assembly resolution, and this is in the form of a multilateral treaty. Multilateral treaty. Okay. And this treaty, multilateral treaty, is making the parties commit to respect the civil and political rights of individuals, including the right to life, freedom of religion, freedom of speech, freedom of assembly, and freedom of fair trial, right? Freedom of fair trial. Okay. And India has signed it and we have ratified it both. Signing was also done and ratification has also been done by India. This is what you should remember. And this has provisions related to, against torture, which is to be followed by the country. This resolution is of the year 1966, right? This resolution is of the year 1966. We have been telling the world that, see, we are signatory and we have even ratified this International Covenant on Civil and Political Rights, which is protecting the rights of people for fair trial. Okay. And since it protects the right, of people for fair trial, there is no question that while they are in arrest or while they are kept under detention, there will be their rights are being protected as we are the part of this. So even this was in news. But what I would just like you all to remember, that there is a immediate and urgent need in India, right, for police reforms. And I would like you all to remember, right, I would just like you all to remember that as far as police reforms are concerned, various committees we have seen in India related with police reforms. One is Gore committee. I don't want you to remember, right, at least name if you can remember, Gore committee, okay. Then we have seen National Police Commission, Constitution. Then we have seen Constitution of Ribeiro committee. Then in India we also have seen Padmanabhaya committee. All these committees are related with police reforms, okay. All these committees are related with police reforms. Even you should remember the name of Malimath. But this Malimath committee was on criminal justice system, but a lot of recommendation of Malimath committee relates with, right, Malimath committee relates with policing in India, but criminal justice system. Malimath committee is primarily related with criminal justice system. But Soli Sorabji committee, committee was constituted, and based on the recommendation of Soli Sorabji committee, finally this Soli Sorabji committee was constituted in the backdrop of the famous Prakash Singh versus, right, Union of India case, right, Prakash Singh versus Union of India case. And based on this committee recommendation, finally, right, Supreme Court issued directives. Supreme Court issued directives for police reforms in India, and 7 directives are there, okay. 7, but none of the states have complied all the directives till date, but many of them have complied most of the directives, but 7 directives which are there, okay. And directives are, right, directives are, if you ask me, the most important directive is separate investigation, separation of investigation and law and order, maintenance of law and order. These two must be separated, okay. These two must be separated. There should be a separate wing in the state for maintenance of law and order, and there should be a separate wing within the state for investigation. This is one directive of Honorable Supreme Court of India. Directive 2, right, directive 2 relates with appointment of DGP, and tenure of DGP of 2 years. Okay, I don't want to trouble you with too much facts. I just want that finally in 2000, right, finally in 2006, right, Supreme Court issued a directive, 7 directive, DGP appointment, tenure of DGP, okay. Then it talked about establishment of or constitution of or setting up of a state police establishment board, and this board will decide the transfer, posting, promotions, and all other service, right, all other service matters of police officers who are below DSP, right, who are below DSP. So, a state police establishment board, right, a state police establishment board. Then this committee, or the directive of Supreme Court also talked about, right, also talked about a state police complaint authority and district police complaint authority, okay. Meaning what? Now this is something which is a state police complaint authority, and this all the police. Now if today you have a complaint as a citizen, if we have grievance against police, we have to go to police. Okay. So an independent authority should be there where we can go and register any complaint which we have with police. Okay. So a state police complaint authority to entertain complaints of misconduct by police official of the rank of SP and above, and DSP and below. There should be district police complaint authority. Such recommendations are there. Okay, such recommendations are there. Then you know, a state security commission. It also talked about constitution of a state security commission. State security commission, and this will, you know, this will reduce the state government unwarranted influence on police. To eliminate the state government unwarranted influence on police, this commission, okay, this will evaluate the performance of the state police. It will lay down the broad guidelines. We will talk in detail from the mains point of view. The possibility of a question on police reforms is high, right? Police reforms is high. And at the central level, it talked about National Security Commission, and this National Security Commission will take up the task of appointment of Chief of Central Armed Police Force like CISF, BSF, CRPF or CBI or NCB, all such agencies which are there. So 2006 directive of Supreme Court, even if we see today, has not been complied, right, in all respect by all states. Some states have complied 70%, 80%, 60%. I feel time has come when all states should be forced to comply with the directive of this Honorable Supreme Court of India with immediate effect, right, with immediate effect. And always the states are taking a plea that this judgment is, you know, an example of judicial activism, that how can judiciary ask, you know, the state that how the legislative function is to be performed by the state legislature. Can executive ask the judiciary that how judiciary has to pronounce judgments in different cases? So that is what is the area of conflict, but this is an important, you know, judgment. So these were the things which I was interested in discussing with you all. Some more topics are there, but ultimately we have to draw some lines. And I would just like to say a few things to all of you, right? Some other topics which are there is what I will identify and will put it on the portal, or will try to send it, right? We'll try to prepare video and put it on YouTube. That we will see, but we don't want you to burden too much. But yes, right? But yes, if any important topic if is left, we will definitely try to do that. Okay, friends, only thing which I would just like to tell you all that today is 4th of September and 30 days from now, since today is your day of prelims. So next 30 days, you need to work hard. Okay, you need to give your, you know, you need to put your best efforts so that you are able to give your best shot when you go to prelims exam hall on 4th of October. So maybe, you know, 10, 12 hours of study, and that should be primarily focused on revision and consolidation. You will have to say at some point of time in next few days that no more any new reading, only revision of what I have studied till now, so that if any question is from what I have prepared, I should not miss. And you know, if I would just like you all to be aware that if you see, you don't have to score 200 out of 200 to qualify prelims, and prelims is qualifying, right? If you qualify prelims, then you will get the opportunity to write the main exam. So next 30 days, few things are very important. Number one, you need to keep yourself right, in a positive frame of mind. So nothing you should do, and you should not talk to people who are habituated to induce negativity in you. Okay. And if you are able to study well for 30 days, right, with focus on revision and consolidation, solving MCQ, ensuring, right, smart ways, designing smart ways of revision, developing newer ways of revision. Revision is not only, that reading again what you have already read, but revision is solving question, all of a sudden, just walking on the rooftop, taking a walk on the roof, and while you are walking, you are discussing with yourself. You gave a call to a friend and you say that in half an hour we should discuss, right, everything about, India's freedom struggle. You ask me 50 questions, I will ask you 50 questions. Solving MCQ. Okay, taking white sheet and brainstorming and writing that on this topic, am I, remembering all 10 important points? Can I recapitulate 10 points? So there are 100 ways of, revision. While you are reading, you record and listen to that recording. There can be n number of ways in which you can revise, but next 30 days, your entire focus should be on revision, consolidation, and, and have faith in the, study which you have done, the effort which you have put, and remain committed that next 30 days, you are just not going to let any page unturned for your success. No stone should remain unturned for your success. Okay. So 10 to 12 hours of study next 30 days, and you need to keep yourself in positive frame of mind. You need to take very good care of your health. You need to ensure that your diet is healthy, proper sleep, and your emotional and social well-being is equally well taken care. So don't indulge into any kind of fight, argument with any friend, relative, family members. As a smart, aspirant, you need to keep yourself at a distance from all such things which may induce, even a small quantity disturbance. That is very important. Then you cannot afford to, fall sick. So you need to take very good care of your health, proper sleep, healthy diet, 10 to 12 hours of study, and 10 to 12 hours of studies which should be focused on revision, consolidation, and revision and consolidation through smarter ways, so that you can revise more in less time. That is what should be your approach. And Jojo sir will take one class on exam handling that will help you to maximize from your end that, while you are in the exam hall, if you stick to those, golden rules, definitely you will be able to give the best shot of yours. So study well. Team ALS is there with you. Once you are, able to give the best shot of yours on 4th of October, we have planned for you people something unique, and for the first time, right, in the history of ALS, we have planned, we don't know, right, how we are going to conceptualize the whole program, but it has already triggered in our mind that we will conduct a accelerated, fast track revision capsule for main 2020, which will be in the form of discussing question answers, subject wise, topic wise, right, 150 word, 250 word, question answer discussion will be there, and we will make you write, we will discuss question answers, and 600 plus questions we will discuss in the 4 paper of GS, and we will ensure that most of the question, if not exactly, thematically is, in the mains question paper which we have discussed in the class. But those are the things which you have to think only after 4th of October 2020, Right now your entire focus should be to give the best shot of yours when you go for prelims 2020. So from my side, I would like to wish you all good luck for exam, good luck for your life, be in touch. Thank you very much. Goodbye.